The courtroom didn't just go quiet. It froze. Chains clinked. A chair scraped. And in a split second, every person in that room realized something was very, very wrong. Because the man standing there wasn't just another defendant. Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. He was the youngest son of one of Hollywood's most recognizable figures. A man whose last name once opened doors, not prison cells. A man now standing in shackles, wrapped in a suicide prevention smock, accused, allegedly, of doing the unthinkable. And the question that ripped through the room wasn't whispered. It screamed through every mind at once. How did it come to this? Before we go any further, let's be clear about one thing. What you're about to hear is not a verdict. It is not a declaration of guilt. It is a story about allegations, charges, public records, courtroom behavior, and a case that has shaken people precisely because of how unbelievable it feels. Because when a name like Reiner appears on a criminal docket, not as a witness, not as a victim's relative, but as the accused, the world stops pretending justice is simple. So let's start at the moment everything cracked open. Nick Reiner, 32 years old, led into court in restraints, not wearing a suit, not flanked by publicists or family members offering quiet support, but isolated, guarded, watched closely by deputies trained to spot danger before it happens. Why? Because prosecutors allege he is facing 2 counts of first-degree murder in the deaths of his parents, actor-director Rob Reiner, and photographer-producer Michelle Singer-Reiner. Allegations so severe that the state is holding him without bail. Allegations so serious that the death penalty is not off the table. Let that sink in. This is not a minor hearing. This is not procedural noise. This is the opening movement of a legal battle that could end with one of the most devastating outcomes the justice system allows. And yet, what made headlines wasn't just the charges. It was what happened in the room. Witnesses described tension so thick it felt physical. Nick Reiner appeared agitated, restless, his movements sharp, his responses clipped. And then, in a moment no one expected, the hearing reportedly spiraled. Voices raised, deputies moving in, the controlled environment of the courtroom suddenly struggling to contain him. People immediately jumped to conclusions. Was it rage? Was it grief? Was it guilt? Or was it something far more complicated? A psychological collapse playing out in real time? Here's the uncomfortable truth. We don't know. Not yet. But what we do know is that courtroom behavior matters. Jurors notice it. Judges notice it. Prosecutors absolutely notice it. And when a defendant appears volatile, every decision afterward is shaped by that perception. So ask yourself this. If you were sitting on that jury someday, and you saw a man in chains lose control before a single piece of evidence was presented, what would you assume? That question alone is why this case matters. Because it sits at the intersection of justice, mental health, privilege, and public judgment. And it forces us to confront how quickly we decide who someone is before the trial even begins. Nick Reiner is not a public figure in the traditional sense. He didn't seek fame. He didn't build a career in front of cameras the way his father did. And yet, the moment his name was read aloud by prosecutors, his identity was no longer his own. He became Rob Reiner's son, a label that cuts both ways. On one hand, it brings relentless attention. On the other, it creates suspicion. People start asking questions that would never be asked of an unknown defendant. Was he protected? Was he ignored? Was he shielded for too long? Or scrutinized unfairly from the start? And then there's the timing. The charges were announced publicly by Los Angeles County District Attorney Nathan Hochman during a news conference that made it clear this case would not be handled quietly. 2 counts of first-degree murder. A special circumstance allegation of multiple murders. An allegation that a dangerous and deadly weapon, a knife, was personally used. Those words aren't chosen casually. They are legal landmines. Each one escalates potential punishment. Each one signals prosecutorial confidence, or at least prosecutorial intent. And when prosecutors stack charges like that, they are telling the defense something very clearly. We are not bluffing. But then comes the contradiction. Because if this case were truly airtight from the beginning, why the suicide prevention smock? Why the heightened concern for Nick Reiner's mental state? Why the visible caution from court staff? That smock is not a costume. It's a protocol, a response to perceived risk. And its presence tells us something critical. Authorities believe this defendant may be in psychological danger to himself or possibly others. So now we're left with two competing images. On one side, a man accused of calculated, brutal acts. On the other, a man treated as fragile, unstable, and at risk of collapse. Which one is real? Or is it possible that both are? That's where this case stops being simple and starts being deeply uncomfortable. Because society likes clean narratives. Monster or victim, evil or broken, guilty or innocent. Real life doesn't work that way. And courtrooms? They are where those messy contradictions are forced into neat boxes. Often too early, often too publicly. Outside the courthouse, cameras rolled. Reporters shouted questions. And Nick Reiner's attorney, Alan Jackson, stepped forward with a message that sounded almost out of place in the chaos. Do not rush to judgment. That phrase hit some people as reasonable. Others heard it as defensive, and many dismissed it entirely. But think about that statement for a moment. In a case this emotionally charged, asking for patience is almost a rebellion. Because public opinion has already begun sentencing. Scroll through social media, and you'll see it. Some users call for maximum punishment. Others speculate about mental illness. A few cling to disbelief, unable to reconcile the allegations with the family name. And that's the danger zone. Because once public narratives harden, they rarely soften, even when evidence contradicts them. This is where we need to slow down. Not to excuse anything. Not to deny victims their dignity. But to understand what we're actually witnessing. This is not just a murder case. It is a case about legacy collapsing under pressure. About how fame does not insulate families from dysfunction. About how mental health concerns intersect, uncomfortably, with violent allegations. And about how a courtroom moment can permanently shape a defendant's fate before trial even begins. Think about the optics. Shackles, a smock, an outburst. Those images will be replayed endlessly. Cropped, reposted, analyzed out of context. They will live far longer in the public imagination than any dry legal filing ever will. So ask yourself again, if you only saw those images, what would you believe? And more importantly, what would you never question? Because the most dangerous thing about cases like this isn't just the crime that's alleged. It's the certainty we build before the truth has a chance to breathe. As this case moves forward, evidence will be introduced. Testimony will be challenged. Psychological evaluations may surface. Motives will be argued. Timelines will be reconstructed. But right now, at this very beginning, we're standing at a crossroads. One path leads to a narrative of pure monstrosity. The other leads into the murky territory of mental collapse, family strain, and unanswered questions. And the courtroom eruption we witnessed? It may not be a distraction. It may be the first clue. Because what caused Nick Reiner to lose control that day wasn't random. And when we uncover what happened just before he stood up in that courtroom, everything about this case may shift in ways no one is prepared for. What if it was the warning? Because moments before Nick Reiner stood up in that courtroom, something happened that almost no one in the gallery noticed, and fewer still understood. A glance, a whispered exchange, a document slid across a table and pulled back just as quickly. Small things, easy to miss. But in courtrooms, small things are often the beginning of disasters. This is Chapter 1, the day the courtroom lost control. And to understand why that moment mattered so much, you have to understand how tightly controlled courtrooms really are. They are not chaotic places. They are engineered environments. Every movement is anticipated. Every reaction is monitored. Deputies don't just stand around for show. They're trained to read posture, breathing, eye movement. Judges can sense tension before a word is spoken. Prosecutors know when a defendant is slipping. Defense attorneys feel it in their gut. And that morning, every instinct in that room was on edge. Nick Reiner was brought in early, not through the main entrance, not with the casual shuffle you sometimes see in routine hearings. He was escorted deliberately, flanked closely, guided into position as if court officials were preparing for something they didn't want to name out loud. Why? Because this wasn't just another arraignment. This was the first time the public would see him after the charges were formally announced. And optics matter. He wasn't wearing civilian clothes. No dress shirt. No tie. No attempt to present normalcy. Instead, the suicide prevention smock hung loosely, shapeless, stripping away any visual cues of identity or status. That alone sent a message. This defendant is considered a risk. To whom? That's where the interpretations start to split. Some say it was for his own protection. Others say it was for the safety of everyone else. And a third group believes it was something far more calculated, a preemptive move to control the narrative before it spiraled. Because the moment cameras captured that smock, public perception locked in. Fragile, dangerous, unstable. Pick your label. Now imagine being the person inside it. You're 32 years old, accused of killing your parents. Your name is everywhere. Your family history is being dissected by strangers. And you're standing in a room where everyone is already watching you for signs of collapse. How would you hold it together? Better question. Could you? The hearing began the way most do. Procedural language. Formalities. Dates. Charges read aloud with the clinical detachment only legal professionals can maintain in the face of horror. 2 counts of first-degree murder. Special circumstances. Use of a deadly weapon. Each phrase landed like a hammer. And with every word, Nick's posture shifted. At first, it was subtle. A tightening of the shoulders. A bounce of the knee. Fingers curling and uncurling inside the restraints. Deputies noticed. They always do. The judge noticed too. There was a pause. A look over the bench. A moment where the pace slowed just slightly, as if the room itself was holding its breath. Then something changed. Nick leaned forward. Not aggressively. Not yet. But with intent. He looked toward the defense table. Then toward the prosecution. Then, and this is the part that would later become significant, toward the gallery. Who was he looking for? A family member? A familiar face? Or someone he didn't expect to see? That question still doesn't have a clear answer. But what came next did. His breathing changed. Shallow. Fast. The kind of breathing that tells trained eyes a person is approaching a threshold. And then he spoke. Not loudly. Not at first. A few words. Too quiet for microphones to catch clearly. Enough for the people closest to him to stiffen. The defense attorney leaned in. Whispered something back. A hand gesture. A subtle shake of the head. No. That's what the gesture seemed to say. No. Not now. But whatever restraint was holding Nick together at that point was already fraying. Because seconds later, his voice rose. Not into a scream. Into something worse. A raw, uncontrolled outburst that cut through the room and shattered the careful balance of the hearing. Chairs scraped. Deputies moved. The judge called for order. And in that moment, the courtroom stopped being a place of procedure and became a place of crisis management. This is the part people love to simplify. They say he went crazy. They say he lost it. They say he started fighting. But that language erases something important. This wasn't a bar fight. It wasn't chaos for chaos's sake. It was an emotional detonation under extreme pressure, in a setting designed to expose every weakness. And the response was immediate. Deputies closed in. Commands were issued. Hands went to restraints. The physical choreography of containment played out with practiced precision. Nick was subdued quickly. That's important. There was no prolonged struggle. No injury reported. No drawn-out scene. Which raises another uncomfortable question. If this was a calculated attempt to disrupt proceedings, why did it end so fast? And if it wasn't calculated, what triggered it? Because here's the thing most headlines didn't mention. This outburst didn't come out of nowhere. There were signs leading up to it. And those signs trace back to the hours, and possibly days, before Nick ever entered that courtroom. According to sources familiar with the process, Nick had been informed of specific prosecutorial intentions shortly before the hearing. Not just the charges themselves, but how aggressively the state planned to pursue them. No bail. Special circumstances. A case strategy that signaled maximum exposure. Imagine hearing that when you're already isolated, already under observation, already stripped of control. Some defendants shut down. Others explode. Which response looks more dangerous? The court clearly thought it was prepared. But preparation doesn't equal immunity. Because once Nick was removed from the immediate situation, the damage was already done. The image was out there. The narrative had begun forming. And people filled in the blanks instantly. Some saw guilt. Some saw madness. Some saw a man cracking under the weight of unimaginable loss and accusation. But almost no one asked the hardest question. What if the outburst wasn't about anger at all? What if it was fear? Fear of what? The charges? The sentence? Or something the public doesn't know yet? Because when someone reacts that viscerally in a controlled environment, It's often because they believe something irreversible is about to happen. And here's where this case takes a turn that most coverage skipped entirely. After the courtroom was stabilized, the hearing resumed. Quietly, efficiently, almost as if the eruption hadn't happened. But behind the scenes, everything changed. Additional precautions were ordered. Mental health evaluations were prioritized. Security protocols were adjusted. Why escalate if the threat was gone? Unless the threat wasn't the outburst itself. Unless the court realized something deeper was unfolding. This is where defense strategy becomes critical. Because the defense didn't argue the outburst. They didn't deny it. They didn't try to spin it as misunderstanding. They let it sit. Why? Because sometimes the most powerful move in court isn't explaining behavior. It's letting the court wonder why it happened. And that brings us back to that phrase spoken outside the courthouse. Do not rush to judgment. It wasn't just a plea to the public. It was a signal. A signal that what people thought they saw might not be what it meant. That behavior doesn't exist in a vacuum. That this case is not going to be as simple as headlines want it to be. So ask yourself this. If Nick Reiner was truly beyond control, why wasn't the hearing terminated entirely? If he was simply acting out, why the careful, almost cautious response afterward? And if this was a psychological break, why are there whispers of evidence that could reframe everything? Because sources close to the case suggest that the outburst may coincide with a revelation. Something Nick learned shortly before court that day. Something about the case. Something about the narrative. Something about how his actions would be portrayed. Or perhaps something about how someone else's actions would be portrayed. That's the thread investigators, attorneys, and yes, the court itself are now quietly pulling on. And the more they pull, the more it threatens to unravel assumptions on both sides. Because the day the courtroom lost control may not have been the day Nick Reiner lost control at all. It may have been the day the story we think we understand started to break apart. And when we examine what Nick knew before he stood up, what he was shown, what he was told, and what he realized in that moment, the meaning of that outburst could shift from spectacle to signal. But to understand that, we have to go back. Back before the courtroom. Back before the charges. Back to who Nick Reiner was long before anyone called him a defendant. And that's where the next chapter begins. Who was Nick Reiner before the courtroom? Before the shackles? Before the smock? Before a last name became a headline instead of a shield? That question matters more than people realize. Because juries don't just decide what happened. They decide who they believe is capable of doing it. And identity, not evidence, is often the first verdict people reach. So let's rewind. Long before deputies tightened restraints around his wrists, long before prosecutors stacked charges that could end a life on death row, Nick Reiner was just a kid growing up in the shadow of something enormous. Fame. Not the fun kind. Not the red carpet snapshots or award show applause. The kind that fills a room even when no one is talking about it. The kind that defines expectations before a word is spoken. Nick Reiner grew up in a household where the name on the mailbox carried weight. Where strangers knew his father's work long before they knew his own face. Where introductions came with assumptions baked in. Think about that for a moment. If your last name opens doors, what happens when you don't want to walk through them? If success is expected, what happens when you're unsure what success even looks like for you? Those questions don't make headlines, but they shape people quietly over years. Friends from earlier chapters of his life described Nick as reserved. Not withdrawn exactly, but not hungry for attention either. He wasn't the loud one. He wasn't chasing cameras. He didn't build a public persona. And in Hollywood families, that alone makes you an outlier. Because silence in a loud world often gets misread. Some interpreted it as brooding. Others saw sensitivity. A few mistook it for entitlement. But those who knew him best say Nick struggled with something far less dramatic and far more common. Direction. What do you become when the path in front of you is already paved by someone else's legacy? That question doesn't come with an instruction manual. And when people talk about privilege, they often ignore the psychological trade-off. Yes, resources exist. Access exists. But so does pressure. Unrelenting, unspoken pressure to either live up to a standard or reject it entirely. Neither option is easy. Nick didn't follow the traditional Hollywood track. He didn't chase acting roles. He didn't leverage his name into instant visibility. Instead, he drifted. As this case moves forward, the defense will likely dig into that night with surgical precision. They will ask what Nick was experiencing mentally. They will ask whether there was a break from reality. They will ask whether the events unfolded in a way that supports intent or collapse. And the prosecution will counter with structure, certainty, and severity. But right now, we're standing at the edge of that night, looking in. And what we see isn't clarity. It's fog. Fog that hides not just actions, but understanding. Because until we know exactly what happened in those hours, every reaction afterward, the outburst, the silence, the fear, remains open to interpretation. And when interpretation replaces fact, justice becomes a battle of stories. The next chapter isn't about what happened that night. It's about how the state decided to tell that story. And once prosecutors reveal why they're pushing this case as aggressively as they are, once we examine the legal strategy behind the charges, the stakes will become terrifyingly clear. Because when the state comes for everything, it's because they believe they can take it. Why did prosecutors come out swinging? Why stack charges so aggressively, so early, in a case already drenched in attention and emotion? Because when the state chooses escalation, it's rarely about anger. It's about leverage. Inside the charges, and why the prosecution went nuclear. From the outside, the announcement felt blunt, almost brutal. A press conference. Formal language. No hesitation. 2 counts of first-degree murder. A special circumstance of multiple murders. An allegation of personal use of a deadly weapon. No bail. Death penalty eligibility. To the public, it sounded like certainty, like the state had already solved the puzzle. But inside the legal system, moves like this signal something more strategic. Because prosecutors don't just file charges. They build narratives. And this narrative was built to dominate the room before the defense ever had a chance to speak. Let's break that down. First-degree murder isn't just about killing. It's about intent, premeditation, deliberation. It tells a jury, from the very beginning, that the state believes this wasn't an accident, wasn't impulsive, wasn't the result of confusion or loss of control. It was planned. Or at least, that's what the charge implies. Now add the special circumstance. Multiple victims. That's not redundant. It's deliberate. Special circumstances exist to raise the ceiling of punishment. They unlock harsher sentencing options. They narrow the jury's emotional escape routes. When jurors hear special circumstance, they hear severity. They hear extraordinary wrongdoing. And then comes the weapon allegation. Personal use of a knife. That phrase is carefully chosen. It emphasizes closeness, contact, physical engagement. It strips away any sense of distance or detachment. This wasn't a push from afar. This was up close. And every part of that charging structure does one thing very well. It corners the defense. Because when the charges are this severe, the defense doesn't get to argue around the edges. They don't get to downplay. They don't get to rely on ambiguity. They are forced into a narrow lane. Mental state, intent, capacity. That's it. And that's exactly where prosecutors want them. Now here's where things get interesting. Because aggressive charging isn't always a sign of overwhelming evidence. Sometimes, it's a response to uncertainty. When prosecutors fear complexity, psychological, emotional, narrative complexity, they often counter with force. Why? Because force simplifies. It tells jurors what to think before they think it themselves. And it creates a gravity that's hard to escape. Ask yourself this. If the evidence were absolutely airtight, would prosecutors need to lean this hard on optics? Not necessarily. But in high-profile cases, optics matter almost as much as facts. Because the state isn't just arguing to 12 jurors. It's arguing to the public, to future witnesses, to the defense, to the judge. This was a statement. And statements like this are meant to discourage alternative interpretations before they gain traction. But there's a risk. Because when the state pushes too hard, too fast, it invites scrutiny. Defense attorneys start asking questions like, why no bail immediately? Why the death penalty mentioned now? Why this level of escalation before all evidence is aired? Those questions don't accuse. They imply. An implication is powerful. Let's talk about bail. Holding someone without bail isn't just about risk of flight. It's about perceived danger. To the public, to the process, to themselves. When a judge agrees to no bail, they are saying, on the record, that releasing this person poses unacceptable risk. That decision shapes everything that follows. It affects jury selection. It affects media coverage. It affects how mental health arguments are received. Because once someone is labeled too dangerous to release, the bar for sympathy rises sharply. Now combine that with the suicide prevention measures. On one hand, it signals concern for mental health. On the other, it reinforces instability. And instability cuts both ways. For the defense, it supports arguments about mental state. For the prosecution, it raises questions about control. Was he unstable or unpredictable? That distinction matters. Unstable defendants can be seen as less culpable. Unpredictable defendants are often seen as more dangerous. And the prosecution will lean into the second interpretation whenever possible. But here's the contradiction they have to manage. If Nick Reiner is too unstable to be released, too volatile to trust, too fragile to be left alone, then how does that square with an argument of careful premeditation? Those two narratives don't sit comfortably together. And that tension is where the defense will live. Because every aggressive charge opens a door for cross-examination later. Every assumption invites challenge. And every early declaration locks the state into a story they can't easily revise. Now let's talk about timing. Why announce everything at once? Why not file incremental charges? Why not leave room to adjust? Because momentum matters. Early momentum shapes perception. And perception influences cooperation. Witnesses are more likely to come forward when they believe the state is confident. Experts are more likely to align when the charges feel serious. And jurors are more likely to internalize severity when they hear it from day one. But momentum is a double-edged sword. Because once you build it, you can't stop. You have to keep feeding it. And if later evidence complicates the picture, if mental health evaluations reveal nuance, if timelines introduce ambiguity, the prosecution risks appearing overstated. That's dangerous, which is why prosecutors are believed to be sitting on some information, not because it's weak, but because it's delicate. Details that could humanize the defendant too early, details that could invite empathy before the jury is seated. And empathy is the enemy of certainty. This is why the defense has been quiet. No press conferences, no emotional appeals, no public counter-narrative yet. Silence isn't weakness, it's patience. Because the defense knows something crucial. The louder the prosecution speaks now, the harder it will be for them to pivot later. And pivoting is sometimes necessary when cases evolve. Think about the courtroom outburst again. From the prosecution's perspective, that moment could be framed as proof of volatility. But from the defense's perspective, it's evidence of fragility. Same event, two narratives. And the charging strategy determines which narrative gets oxygen. Here's another angle most people miss. High-profile cases with famous names are risky for prosecutors too. Lose one, and it's remembered. Win one, and it's scrutinized. There is no quiet success. Which means prosecutors often feel pressure to demonstrate strength early, to show they are not influenced by fame, to prove the system treats everyone the same. That pressure can shape decisions in subtle ways. Overcharging is rare, but it happens. Not because prosecutors want to be unfair, but because they want to be unassailable. And sometimes, that instinct backfires. Because juries don't like feeling manipulated. They respond to confidence, but they reject overreach. So the prosecution must walk a tightrope. They must maintain authority without appearing excessive. They must argue control without ignoring instability. They must present intent without erasing complexity. That's not easy. And it becomes even harder if evidence emerges that doesn't fit neatly into a story of calculated murder. Which brings us to the most important question of this chapter. What does the state know that the public doesn't? Because decisions like this are rarely made on surface facts alone. They are informed by reports, evaluations, internal assessments, and conversations that don't happen in front of cameras. Somewhere in the prosecution's files is a reason they believe escalation is justified. And somewhere in the defense's files is a reason they believe that escalation will be challenged. Those two reasons have not collided yet, but they will. And when they do, the case will change shape. Because trials aren't static. They evolve. They react. They adapt. And the most dangerous moment for either side is when new information forces a recalibration. We are approaching that moment. Because behind closed doors, legal teams are preparing for something the public hasn't seen yet. A pivot point, a piece of evidence, a testimony. a report, something that will either cement the prosecution's narrative or fracture it. And the way the state charged this case tells us one thing very clearly. They believe they're ready. But belief isn't proof. And confidence isn't immunity. Because the next phase of this case isn't about charges. It's about evidence. And once we step into what prosecutors say they have, once we examine the knife allegation, the forensic trail, and the physical story they plan to tell, the picture may become clearer, or far more disturbing than anyone expects. What kind of violence leaves almost no sound? What kind of act happens so close, so personal, and yet slips past an entire neighborhood unnoticed? Because once prosecutors introduced the knife allegation, this case stopped being abstract and became disturbingly intimate. This is Chapter 5, The Knife, and Why It Changed Everything. A knife is not a distant weapon. It doesn't allow for detachment. It doesn't create space. It forces proximity. When prosecutors allege personal use of a knife, they aren't just describing a tool. They're describing a moment, a physical encounter, a decision made face-to-face. And jurors understand that instinctively. That's why knife allegations carry emotional weight in court far beyond their technical classification. They trigger visceral reactions. They collapse moral distance. This wasn't something done remotely. This was close enough to see expressions, close enough to hear breathing, close enough to hesitate, or not. So when the state added the knife allegation, they weren't just strengthening their legal position. They were shaping how jurors would imagine the crime. And imagination is powerful. But imagination is also dangerous, especially when facts are incomplete. Because here's the problem. The public doesn't yet know how the knife was used. We don't know how many wounds were inflicted. We don't know where. We don't know in what order. We don't know whether the victims were asleep, awake, or aware. Those details matter enormously because they determine whether the act looks like frenzy or control. A single wound tells a different story than multiple. Defensive wounds tell a different story than none. Sequential injuries tell a different story than simultaneous ones. And right now, prosecutors are holding those cards close. Why? Because once you reveal forensic detail, you can't put it back. And every detail becomes a battlefield. Defense attorneys dissect wound patterns. They question angles. They explore timelines down to seconds. A knife case lives or dies on specificity, which means the state must be confident, not just emotionally, but scientifically. Now consider this. Knife crimes often involve noise, movement, struggle, furniture shifts, objects fall, voices rise. But in this case, there were no reports of neighbors hearing anything unusual that night. No calls, no alarms, no immediate response. That silence is unsettling, and it forces investigators to confront possibilities they'd rather not. One possibility is timing, early morning, deep sleep. Another is surprise, a moment before fear registers. Another is something even more disturbing. Trust. People don't scream when they don't perceive danger. They don't fight when they don't believe they need to. Which leads to a question no one wants to ask out loud. Were the victims aware of what was happening when it began? That question will haunt this trial. Because awareness changes everything. If someone is asleep, that suggests opportunity. If someone is awake but unsuspecting, that suggests betrayal. If someone is alert and resisting, that suggests conflict. Each version points to a different psychological state, and the knife becomes the key to unlocking which one the prosecution believes occurred. Now let's talk about the physical implications for the accused. Using a knife leaves evidence. Cuts, nicks, blood transfer, microtraces. It's not clean, which means investigators will be looking for injuries on Nick Reiner himself. Hands, arms, clothing, and the absence or presence of those details will matter just as much as the injuries to the victims. Because defensive wounds don't only appear on victims. They appear on perpetrators too, unless there was no resistance. Unless the attack was one-sided. Unless something prevented resistance altogether. This is where forensic silence becomes as important as forensic evidence. And it's also where defense arguments begin to take shape. Because if there are inconsistencies, if wound patterns don't match a narrative of prolonged struggle, the defense will seize on that. They will ask whether the act was impulsive or dissociative. They will ask whether Nick was in a state of altered consciousness. They will ask whether mental collapse, not calculation, drove the moment. And the prosecution will counter by emphasizing choice. The choice to pick up a weapon. The choice to approach. The choice to act. Choice is everything in first-degree murder cases. But here's the contradiction that makes this case so volatile. If the act was as intimate and personal as the knife allegation implies, why was there such emotional collapse afterward? Why the outburst? Why the visible instability? Why the suicide prevention measures? Cold, calculating killers don't usually unravel immediately in public. That doesn't mean they can't, but it does complicate the narrative, because prosecutors must reconcile two images: a person capable of deliberate, intimate violence, and a person visibly falling apart under pressure. Those images don't cancel each other out, but they pull in opposite directions. Now let's address something else people rarely think about. Knife crimes often involve hesitation. There is usually a moment where the brain resists, where instinct says stop. Crossing that line takes something powerful: rage, fear, delusion, or detachment. Each has different psychological fingerprints, and experts will be brought in to interpret those fingerprints. Psychiatrists will talk about dissociation. Forensic psychologists will talk about impulse control. Behavioral analysts will talk about escalation. All of them will argue from the same physical facts, and jurors will be asked to decide which interpretation feels most true. That's why the knife allegation is both powerful and precarious. It demands explanation, and explanations invite doubt. Because if prosecutors fail to explain how such an intimate act occurred without noise, without interruption, without immediate detection, jurors will start asking questions of their own. Questions like, why didn't anyone hear anything? Why wasn't help called sooner? Why did the accused leave rather than stay? Why did the breakdown happen in court, not at the scene? Those questions don't accuse. They destabilize. And destabilization is exactly what defense teams aim for in cases like this. Now consider the aftermath again. Nick Reiner allegedly fled. But fled to where? And in what state? Did he attempt to hide evidence? Did he discard anything? Did he seek isolation? Those answers matter because they speak to awareness. Awareness of wrongdoing is not the same as intent to kill, but juries often conflate the two, and prosecutors rely on that. But defense attorneys are trained to separate them, to argue that awareness can arrive after the fact, that someone can realize what they've done only once the shock lifts, and that realization can trigger panic, not planning. This is especially true in cases involving mental breakdowns. People don't behave logically in the aftermath of psychological collapse. They behave instinctively. They run. They hide. They shut down. And when they are later confronted with the consequences, in court, under lights, under scrutiny, the collapse resumes. That pattern would explain the courtroom outburst. But explanation is not proof. And proof is what the jury will demand. Which is why the knife allegation is the prosecution's double-edged sword. It strengthens their case emotionally, but it forces them to answer harder questions factually. Because intimacy without noise demands explanation. Control without composure demands explanation. And violence followed by visible disintegration demands explanation. Somewhere in the forensic evidence is the prosecution's anchor. A detail they believe resolves those contradictions. It could be wound patterns. It could be blood evidence. It could be the position of the bodies. It could be something the defense hasn't seen yet. But until that anchor is revealed, the knife allegation hangs in the air, heavy, evocative, and incomplete. And incomplete stories are dangerous in court, because jurors fill in gaps with intuition. And intuition is shaped by empathy as much as logic. As this case moves forward, the knife will become more than an allegation. It will become a focal point, a symbol, a test of whose narrative holds together under scrutiny. And once forensic experts take the stand, once diagrams are shown, once language turns clinical, the emotional temperature of this trial will spike. Because nothing strips away distance like detail. And when those details finally come out, they may confirm the prosecution's confidence, or introduce doubts no amount of aggressive charging can erase. The knife didn't just change the case. It forced everyone involved to confront the most uncomfortable possibility of all, that this wasn't a moment of blind rage, or that it wasn't. And the difference between those two interpretations could mean the difference between life and prison, and death. Why was he wearing the smock? Not metaphorically, not symbolically, literally. Why did the court decide that a grown man, accused but not convicted, needed to be wrapped in a garment designed to prevent self-harm. But inside the justice system, that garment has a very specific meaning, and it's far more nuanced than headlines suggest. A suicide prevention smock is not punishment. It's protocol. It's used when authorities believe a person is at risk of harming themselves, not when they want to shame them, not when they want to make a statement, and not when they want to create a spectacle. So the first question we have to ask is this: who made that call? Because no one puts a defendant in a suicide prevention smock casually. It requires assessment, observation, documentation, and usually multiple professionals agreeing that the risk is real. That means someone, or several people, saw something in Nick Reiner that set off alarms. Something before the courtroom outburst. Something before the cameras. Something that told them this wasn't just stress or nerves. So what did they see? Court officers are trained to notice patterns most people miss. Changes in breathing, withdrawal, agitation followed by flatness. Statements that don't sound dramatic but feel final. You don't need a confession to recognize despair. Sometimes despair announces itself quietly. And the presence of that smock tells us that, at least in the eyes of the system, Nick Reiner wasn't just dangerous. He was vulnerable. That's a word people struggle with in cases like this, because vulnerability doesn't sit comfortably next to murder charges. But the law doesn't deal in comfort. It deals in risk. Risk to others. Risk to process. Risk to self. And the risk to self was clearly taken seriously here. Now ask yourself something uncomfortable. If prosecutors truly believed Nick Reiner was a cold, calculating killer, composed, deliberate, in control, would suicide prevention have been the priority? Not always. But often, no. Calculated offenders are typically monitored for manipulation, not collapse. The smock suggests concern about implosion, not deception. And that distinction matters, because it introduces a contradiction the prosecution will have to manage carefully. On one hand, they argue intent, planning, and deliberate action. On the other, the system is signaling psychological fragility. Those two narratives can coexist, but only if they're handled precisely. Too much emphasis on fragility, and the jury starts questioning intent. Too much emphasis on intent, and the smock starts looking performative or excessive. Neither side wants that tension exposed too early. That's why this chapter matters. Because the smock is not just fabric. It's a message. And messages like this don't stay hidden forever. Now let's talk about what the smock does to perception. In court, optics are everything. A defendant in a tailored suit looks different than one in restraints. A defendant in restraints looks different than one in a suicide prevention smock. Each layer strips away normalcy. Each layer tells the jury, this person is not like you. And that can cut in two directions. Some jurors feel fear. Others feel pity. And the line between those two emotions is thin. Prosecutors want jurors to feel cautious, not compassionate. Defense attorneys want jurors to see humanity, not threat. The smock complicates both strategies, because it forces jurors to confront something deeper than guilt or innocence. Mental collapse. And mental collapse is not something people agree on easily. Some see it as explanation. Others see it as excuse. And some reject it entirely. That's why mental health arguments are among the riskiest in criminal trials. They can save a defendant, or they can alienate a jury. Now consider the timing again. The smock wasn't introduced quietly behind the scenes. It was visible, public, impossible to ignore. Which raises another question. Was this about protection or control? Because suicide prevention measures also limit movement. They reduce access. They restrict autonomy. And in high-stakes cases, control is everything. A defendant who harms themselves before trial changes everything. It halts proceedings. It shifts narratives. It introduces chaos. Courts are desperate to avoid that. So the smock serves a dual purpose. Protect the defendant. Protect the process. And when a court chooses process protection early, it suggests they believe the risk is real, not hypothetical, not distant, immediate. That alone should give you pause. Because whatever Nick Reiner was experiencing internally was serious enough to trigger intervention before the trial even began. And that internal state didn't appear overnight. Mental collapse doesn't usually announce itself on a single morning. It builds, quietly, over time, through stressors, through loss, through fear, and sometimes through the realization that life, as you knew it, is over. Now connect this back to the courtroom outburst. People often assume the outburst caused the smock, but that may not be true. In many cases, the smock comes first, based on evaluations, based on behavior in custody, based on statements made off camera, which means the eruption in court may not have been the trigger. It may have been the confirmation that the assessment was correct, that whatever risk they feared was escalating, not stabilizing. And that raises a chilling possibility. What if the court wasn't surprised by the outburst at all? What if they were bracing for it? If that's the case, then the courtroom moment wasn't chaos. It was forecast, and forecasts don't happen without data. So what data did they have? We don't know yet, but we can infer some possibilities. Statements Nick may have made while in custody, behavior observed during transport, reactions to legal information shared privately. Each of those moments happens outside public view, and each can influence how a defendant is handled. Defense attorneys are acutely aware of this. They monitor their clients constantly, not just for strategy, but for safety, because a client who collapses before trial is a legal and human catastrophe. So when the defense says, "Do not rush to judgment," that message isn't only about public opinion. It's also about mental state. It's about slowing everything down, giving space, preventing irreversible outcomes. Now let's talk about what jurors will eventually be told. At some point, mental health evaluations will surface. Reports, expert opinions, diagnostic language. Those documents will try to answer a question that haunts every case like this. Was Nick Reiner capable of forming intent at the time of the alleged crime? That question sits at the intersection of law and psychology. And it's where trials are often decided. If experts testify that he was in a dissociative state, suffering from a break with reality, or unable to fully comprehend his actions, the narrative shifts. Not toward innocence, but toward diminished capacity. And diminished capacity changes outcomes. But those arguments are fragile. They depend on credibility, consistency, and timing, which is why the smock matters so much. Because it anchors claims of mental fragility in observable reality. It says, this concern existed before trial strategy, before jury selection, before spin, and that gives it weight. But again, weight cuts both ways. Because the prosecution can argue that mental fragility makes someone more dangerous, not less. Unpredictable, uncontrollable, capable of extreme acts without warning. And that argument resonates with jurors too. This is why cases involving mental health are never clean. They force people to confront contradictions they don't want to resolve. Can someone be both broken and responsible? Can someone be both ill and accountable? Can someone be both dangerous and deserving of compassion? There are no easy answers, and the smock drags those questions into the open. Now consider this. If Nick Reiner truly believed his life was over, legally, socially, existentially, despair would be a rational emotional response, not a justification, an explanation. And explanations matter when courts decide how to proceed. Sentencing, treatment, placement. Everything changes if mental collapse is real. That's why the court's early intervention is so telling. They didn't wait. They didn't gamble. They acted, which suggests urgency. And urgency suggests severity, not just of the charges, but of the psychological risk. As this case moves forward, the smock will fade from daily headlines. But it will not fade from the courtroom. Because jurors will remember it. Judges will remember it. Experts will reference it. It will become part of the narrative whether either side wants it to or not. And the defense will eventually ask the question the public is avoiding. If Nick Reiner was stable, calculating, and fully in control, why did the system treat him like someone on the brink? That question doesn't accuse. It destabilizes. And destabilization is exactly where reasonable doubt is born. But the prosecution has an answer ready. They will argue that the smock proves nothing about intent. That collapse after the fact doesn't erase choice before it. That despair doesn't negate decision. And jurors will be asked to choose which interpretation feels true. That choice will define everything. Because once we move past the optics, past the charges, past the headlines, this case becomes about something far more uncomfortable than guilt. It becomes about how the justice system handles people who break, violently or otherwise, under pressure. And the next chapter brings us face to face with the people who will frame that question most aggressively of all, the defense. Because when Nick Reiner's attorney finally steps fully into the spotlight, When the silence ends and strategy emerges, we will see how this case is really going to be fought. Not on facts alone, but on the meaning of collapse itself. What kind of father was Rob Reiner behind closed doors? Not the public figure, not the filmmaker, not the voice people recognize instantly. The man inside the house. Because once a case like this reaches this stage, nothing is sacred anymore, not even memory. This is Chapter 7. Rob Reiner, the father the public thought they knew. For decades, Rob Reiner existed in the public imagination as something almost fixed. Familiar, affable, predictable. The director who made people laugh. The actor whose presence felt reassuring. The political voice who spoke loudly and confidently about justice, morality, and values. He was, to many, a symbol of decency. And symbols are dangerous in criminal cases. Because when tragedy strikes someone so well known, people instinctively protect the image or attack it. Rarely do they examine it. But the justice system doesn't care about symbols. It cares about relationships. And in a case involving alleged familial homicide, the relationship between parent and child becomes central. Not as a judgment of character, but as a context for motive, behavior, and psychological dynamics. So the question prosecutors and defense attorneys alike will eventually ask is not whether Rob Reiner was respected publicly. It's whether he was understood privately. And that is a much harder question. Families are ecosystems. They develop patterns, roles, unspoken rules. And in families touched by fame, those patterns often become distorted. Not necessarily abusive, but asymmetrical. Power shifts. Attention shifts. Expectations shift. A famous parent doesn't have to be cruel to be overwhelming. Presence alone can dominate a household. And that dominance, even when benevolent, can shape children in ways outsiders never see. People who knew the family describe Rob Reiner as involved, opinionated, intellectually intense. A man who believed deeply in ideas and principles. That intensity worked brilliantly in public life. But inside a family, intensity can land differently. Especially on a child who isn't built to compete with it. Nick Reiner was not a performer, not a public speaker, not a figure who thrived in confrontation. Which raises a question no one likes to ask. What happens when a child grows up under the shadow of a parent whose voice fills every room? Some children rise to it. Others shrink. Neither response is wrong. But the shrinking often goes unnoticed. An unnoticed emotional withdrawal can turn inward over time. That doesn't mean Rob Reiner failed as a father. It means the dynamic may have been more complicated than the public narrative allows. Friends of the family have spoken, cautiously, about a household that valued intellect, debate, and strong opinions. That kind of environment can be stimulating. It can also be exhausting, especially for someone who processes emotion internally. Now let's address the obvious tension. If Rob Reiner was such a strong, moral presence, how could this happen? That question assumes a direct line between morality and outcome. Real life rarely works that way. Parents can do many things right and still lose sight of a child's internal struggle. Not because they don't care, but because they assume resilience where fragility exists. And fragility is often hidden in families that appear strong from the outside. Another layer complicates this further. Rob Reiner was not just a father. He was a public figure with opinions. Strong opinions. Political opinions. And when a parent is publicly vocal, disagreements at home can take on an added weight. They stop being private. They become ideological. Imagine arguing with someone whose beliefs are broadcast nationally. How do you push back? How do you disagree without feeling small? How do you assert yourself when the world already validates the other voice? Those dynamics don't create violence, but they can create silence. And silence, over time, can ferment into resentment or despair. Again, this is not accusation. It's context, because prosecutors will try to paint a picture of motive. And motive in cases like this often hinges on relationship strain, arguments, conflicts, breaking points. Defense attorneys will counter by emphasizing love, support, normalcy. They will argue that whatever tensions existed were not abnormal. That families argue. That disagreements don't equal danger. And they'll be right. But the truth may live somewhere in between. Because relationships don't need to be toxic to be strained. They don't need to be abusive to be suffocating. And suffocation doesn't announce itself with bruises. It manifests as withdrawal. Now consider something else. Rob Reiner was older, 78 years old. Age changes family dynamics. Parents become less physically dominant, but often more emotionally fixed. Routines become entrenched. Expectations harden. And adult children navigating their own instability can feel trapped between independence and obligation, especially if they live close, especially if boundaries are unclear. Investigators will examine whether Nick lived with his parents, whether he depended on them, whether he felt unable to leave. Dependency is not weakness, but dependency combined with psychological distress can become volatile because it collapses perceived options. And when people feel they have no options, they sometimes do unthinkable things. This is where the prosecution may attempt to introduce conflict. Arguments over living arrangements, money, autonomy, control. Even subtle tensions can be reframed dramatically in court. Defense attorneys know this. That's why they often fight hard to keep family disputes out of evidence unless directly relevant, because jurors tend to magnify family conflict once violence has occurred. Every argument becomes a precursor. Every disagreement becomes motive. That's dangerous, because hindsight distorts. Now let's talk about Michelle Singer Reiner. Often quieter in public, less visible, less vocal. But in families, quieter figures sometimes hold emotional gravity others don't. They mediate. They buffer. They absorb. If Michelle served as an emotional bridge between Rob and Nick, her presence may have softened tensions. Her absence, whether emotional or physical, may have destabilized them. And that possibility is critical, because in many family tragedies, violence occurs after a perceived loss of balance. A moment when a stabilizing figure is no longer present, emotionally or psychologically. We don't yet know the sequence of events that night. We don't know who encountered whom first. We don't know who was aware of what. But investigators will examine whether dynamics shifted in those final hours, whether arguments escalated, whether something snapped. And those examinations will inevitably circle back to Rob Reiner's role, not as a villain, not as a saint, but as a human being inside a complicated family system. Public narratives resist that. They want heroes and monsters. Real families rarely offer either. Now think about how jurors will approach this. Many will come in with admiration for Rob Reiner. They will recognize his work. They will have opinions. That admiration creates an emotional asymmetry in the courtroom, because it makes it harder to imagine him as part of a dysfunctional dynamic. Defense attorneys will be careful here. They won't attack Rob's character. They'll emphasize love. They'll emphasize tragedy. They'll emphasize that no one wins here. But they will subtly suggest that expectations, pressure, and unspoken strain can exist even in loving families. Prosecutors, meanwhile, may leverage Rob's public image to emphasize betrayal. The idea that someone would harm a father so widely respected adds emotional force to the charges. It amplifies outrage, but it also raises the bar for proof, because jurors will subconsciously demand stronger evidence when the alleged victim is someone they admire. That's a risk prosecutors accept or miscalculate. And this is where the narrative becomes unstable. Because Rob Reiner's public image doesn't simplify the case. It complicates it. It creates emotional noise. It tempts jurors to decide based on feeling rather than fact. Judges are aware of this, which is why jury selection will be critical. Potential jurors with strong opinions about Rob Reiner may be excluded, not because admiration is bias, but because it's influence. And influence distorts deliberation. Now consider Nick again. Growing up as Rob Reiner's son means growing up watched. Not always by cameras, but by expectation, by comparison, by assumption. And if Nick struggled internally, that pressure may have magnified his isolation. Isolation doesn't excuse violence, but it can explain collapse. And collapse is the defense's doorway, because mental collapse reframes behavior. It doesn't erase it. It contextualizes it. And in a death penalty case, context can mean the difference between life and death, which brings us back to the outburst, the collapse in court. Seen by many as disrespectful, by others as tragic, by the defense as symptomatic. If Nick truly experienced his father as a towering figure, emotionally, intellectually, the realization that his father was gone may not have landed immediately. Shock delays grief. Denial delays reality. And when reality arrives, it often arrives violently. Not outwardly violent, emotionally violent. which could explain why the collapse happened in court, not at the scene. Court is where finality becomes real, where names are spoken formally, where charges are read aloud, where the future is defined. That's where people break. And breaking doesn't mean pretending. It means failing to hold together anymore. Now ask yourself this.